welcome everybody as we hit 300 participants, which is amazing. Thanks so much for joining us for this webinar all about the Raeshaw Farms decision from Scotland, which came out recently and has some really interesting things to say about the question that I'm sure lots of you have been thinking about, which is the relationship between environmental assessment and projects under those regulations and what exactly that means, whether they can be dealt with separately or have to be all dealt with together. We've got an absolutely stellar panel to tell you all about it. I'm going to introduce the people in the order they're going to speak. Nina Pindham is one of our absolutely outstanding environmental and planning barristers here at Cornerstone. Her practice includes infrastructure, energy, EIA, SEA, water, air quality, and habitats related work. There's more too, but they were just the ones I picked out. Chambers and Partners described her in 2026 as a rising star, which is obviously well out of date. Her star is absolutely risen. Jack Barber, another of our outstanding junior planning and environment practitioners here at Cornerstone, always in extremely high demand from clients, but also from leaders. He's just a great guy to have on your team, and I know that well. His recent work, he tells me, covers the spectrum of advising and representing developers, local authorities, and interested parties on various infrastructure and renewable schemes, including solar and battery energy storage systems. James Finley, KC, doesn't really need any introduction. There's too much to say about him anyway in order to do so in a 1-hour webinar. He is our head of chambers, joint head of chambers with Robin Green here at Cornerstone. The key point, though, is that he led the successful appellant team in Raeshaw Farms, so there is literally no one better to talk about the case than James. He is, as you all know, a leading practitioner across the fields of environment, planning, local government, public, and unbelievably licensing law, not just in England and Wales, but also in Scotland. And then we're absolutely delighted to have Imogen Dewar join us, who's a senior associate at Pinsent Mason, described to me by Nina as an absolutely stellar infrastructure lawyer. She specialises in renewables, energy transition, and related projects in and around the UK, again, both in England and in Scotland. And Imogen's going to give us, I think, primarily a developer side perspective on the issues that the decision raises. And we are really delighted, Imogen, that you're here with us. My name's Joe Cannon, KC. I have been chosen to chair, I can only assume, because I used to own and run a charcuterie business. So when it comes to salami slicing, I'm the KC you need. That's why I'm here. The broad agenda, and I'm going to ask Nina to start, is we're going to start by looking at the wider European context. Jack is then going to tell us about the domestic case law context pre-Raeshaw Farms. We've then got James to tell us about the decision itself, the facts and what it tells us. And then Imogen's going to come in with the implications essentially for the renewables and EIA environment across the two jurisdictions. Nina, over to you.
Thanks ever so much, Joe. And there is some audio in the background that now seems to be resolved. But if anyone has any issues, technical or otherwise, please do let us know. All right, no slides happily, so I don't have to worry about that tech issue. As Joe indicated, I'm going to give a whistle-stop tour of the EIA directive key provisions just to set the scene and kind of bring us all up to the same level, though looking at the attendee list, you're all extremely expert in this. But in case some of you need some refreshers, the EIA regime actually, funnily enough, originated in America, so some good environmental laws do come out of there. It was under the Nixon administration, funnily enough. Don't worry, I'm not going to give a PhD thesis on that. The regime, as we all know, seeks to ensure that the likely environmental impacts of major projects are considered and assessed before permission for that development is granted. And that's quite clear from Recital 1 of the 2014 Consolidating and Amending Directive, where the aim in Recital 1 is confirmed to contribute to a high level of protection of the environment and human health. And a phrase those who work on the claimant side will know and love, and those who work on the defendant side will be sick of hearing, comes from the Dutch Dykes case, the Krajeweld 1995 decision, where the CJU said the wording of the directive indicates that it has a wide scope and a broad purpose. So high level of protection for the environment, wide scope, broad purpose, and as we're about to see, quite a lot of legal uncertainty that gets worked out in the courts. It's also, I have to say, established case law that effects on the environment should be taken into account at the earliest possible stage. So that kind of sets the scene for the project splitting case law. The 2014 directive at recital 32 confirms that that's because the aim is to integrate environmental considerations at an early stage in the project's design. So we get that repeated throughout the various iterations of the directive. The UK, notwithstanding the clear words of the directive about the wide scope, broad purpose in Krajeweld, etc., was successfully brought to court by the European Commission in 2003 because the UK's domestic legislation then allowed for EIA to be carried out at the outline planning permission stage, but there was no obligation thereafter to consider the matter at subsequent reserved matters approval stage. And that case actually followed the year earlier case of Wells, also known as Congyar Quarry, where the CJU held the decision to approve a new suite of planning conditions under what's known as the Review of Old Mineral Conditions Permission Regime. Review of Old Mineral Permissions Regime, where the conditions are reconsidered. That comprised development consent for the purposes of the EIA directive. And then, no surprise, the Commission then brought proceedings against the UK thereafter. Wells is also the case where the court held that national consent procedures can consist of more than one stage, but where there is a stage involving a principal decision and the other involving an implementing or subsequent decision, which cannot extend beyond the parameters set by the principal decision, which is the regime we have here in the UK, that the effects which the project may have on the environment must be identified and assessed at the time of the procedure relating to the principal decision. But if the effects are not identifiable until the time of the procedure relating to the subsequent implementing decision, then the assessment could be carried out and should be carried out indeed at that stage in the procedure. So we're going to see that thread carried through the jurisprudence. One thing in setting the stage that I need to confirm is the definition of project, very broad. Article 1, that's defined as the execution of construction works or of other installations or schemes and other interventions in the natural surroundings and landscape. So surprise, surprise, lawyers have had fun with that extremely broad wording. Scotland and England, we're talking about two different jurisdictions here. They each have their own implementing regulations. We're going to hear later on the potential differences between those two. But I'm here introducing things, and so for introductory purposes, all I need to say is that each set of those regulations legally prohibits the decision maker from authorizing EIA development until EIA has been carried out, and all environmental information must be taken into account. This is a procedural regime. Unlike the Habitats Directive, for example, under the EIA regime, the decision maker is free to do what they wish so far as it's rational, and no other public law error affects that decision, because what to do post assessment is not dictated in the EIA directive, quite unlike the HABS regs, which gives you a very outcome yes, outcome no, go left, go right. For that reason, I mentioned the procedural nature of the EIA regime because the courts are very comfortable interrogating procedure and the decision-making of public bodies. It's what we do as public lawyers. So there is a lot of case law. We don't have the time. Days wouldn't be enough to go through it all. I'm going to give you some of the highlights. We've all heard of salami slicing. There were project splitting kicked off in Spain in 2001. Then the first mention I could find of salami slicing was actually a European Commission report in 2003, looking at it, reviewing the implementation of the original 1985 EIA directive, where they then used the term salami slicing and saying, this is not something that's acceptable. Notwithstanding that, we come back to Spain for kind of the genesis of the explosion of case law and the unlawful salami slicing of projects. And that's the Ecologistas en Acción Coda case, also known as Madrid ring road case. And so the facts are extraordinary. There are some cases where the facts are just delicious and you know it's going to court. This is one of them. So the national threshold in Spain at the time to carry out EIA for a length of highway domestically was 5 kilometers. So what the Madrid City Council determined to do was to construct a ring road authorizing less than 5 kilometer segments at a time. But as I said, it was a ring road. So no surprise, the CJU had absolutely no patience with that procedural approach and said at paragraph 44 of their judgment, the purpose of the amended directive cannot be circumvented by the splitting of projects, and the failure to take account of the cumulative effect of several projects must not mean in practice that they all escape the obligation to carry out an assessment. When taken together, they are likely to have a significant effect on the environment. Okay, from Spain we go to Ireland. I promised a whistle stop tour. This really will be whistle stop because we started a wee bit late, but we have a lot of people here with a lot of questions, so I really want to get to that. So in Ogrina onboard Planala, I'm trying to do the Irish justice here, a case from 2014. Mr. Justice Payart decided that the failure to have regard to the cumulative effects of the entire development, and the entire development being the wind farm and the grid connection within the EIAs, the failure to assess them together was an error. And he said that that was, notwithstanding each being independent of each other, in reality they were one project. Because the wind turbine development on its own served no function if it could not be connected to the grid. I should say also in Ogrina, the judge said that the lack of formulated proposals for the design and route of the connection, so that the not final details, I can't say incoherent because that wasn't the language used in the case, but the formulative, indicative plans only for the grid connection did not justify treating the two as standalone projects. He found that it was rather suggestive of the permission being sought prematurely, in his view. That was followed in 2017 by Daly and Kilronan, where the same decision was made by Mrs. Justice Baker, where the grid connection to a wind turbine and the wind farm development itself were one and the same project. But importantly, Mrs. Justice Baker did say that it could not be said in absolute terms that the only permissible way in which a planning application for a wind farm could be made was to apply for that alongside the grid connection. So giving procedural flexibility in her decision. Mr. Sweetman comes back into play in Irish jurisprudence, this time with EIA, not habitats, and that's in 2023. And Mr. Justice Quinn gave us quite a lot of helpful indicative pointers for determining whether an entire project for, in this case again, wind farm and the grid connection were one and the same project in reality, notwithstanding their separation in time and application process. I won't go through them, but that's at paragraph 174. So that's Sweetman and Onboard Planala 2023 IAEHC 89, for those who want to take a look at that. And again, we see this thread of the developer saying the practicalities of this being considered one and the same are too difficult, and it makes more practical sense to assess them separately. Mr. Justice Quinn, just like Mr. Justice Payart, didn't have much patience with that argument. He said the practical benefits of assessing the environmental impacts of the construction of a wind farm before and separate to the grid connection, I'm paraphrasing here, that those practical benefits were not of themselves a reason to justify, in his view, what was project splitting. There's one other case to note. We come back to Spain, and this is, I'm not going to pronounce the Spanish pronunciation, attempt the Spanish pronunciation, De Lobo Environmental and Cultural Association and the Directorate General of Energy Planning and Natural Resources. This was a challenge to the separation of a construction project and the relative power line in the EIA. And there, the court concluded that the project consisted of both the wind farm and the production of electrical storage that was then fed into the grid. So all of that was one and the same project that therefore had to be assessed in a single environmental impact statement. Before I hand over to Jack, two quick things to mention. We're going to come back to Ireland. to bring up a point that we might discuss later. And so while I'm kind of setting the scene, I want to bring it out now, which is the Supreme Court of Ireland's decision in National Trust for Ireland in Enbord Planala yet again. This is the Kilkenny cheese case of 2022. And Payart's decision, Mr. Justice Payart's decision in Ogrina was used in that case as obiter, but nonetheless a Supreme Court case of Ireland, considering it worthy of due weight. They said that was an example of a clear and unbreakable interrelationship between the project itself and the certain off-site activities. And that for the purpose of assessing environmental consequences, because of that link, the one and the same project had clearly been established there. And to come back to the UK to kind of bring us territorially onto Jack's territory, that decision in Kilkenny Cheese echoes to my mind the much earlier decision of the Court of Appeal in Burge and Breckland District Council, where the Court of Appeal held that a planning application for a biomass renewable energy plant and a planning application for a combined heat and power plant that was linked to it simply by an underground gas pipe, notwithstanding the single connection only being this one gas pipe, they were not nonetheless a single project on the basis that in the Court of Appeal's words, they were functionally interdependent and could only be regarded as an integral part of the same development. So it'd be really interesting in the discussion to sort of tease out the way forward and if that assists us in any way. But with that teaser, now that we're back in the UK, I'm going to hand over to Jack to follow through on the domestic authorities on project splitting.
Thanks, Nina. Jack, over to you. Relatively coherent line from Europe, but of course, Britain has a proud history in not necessarily following what Europe tells it to do. So over to you for the territorial view.
Thank you very much. I'm glad that I didn't have to do all those pronunciations. Nina, talented linguist, add that to her skill set. In terms of where we are in the UK, obviously Scotland and England and Wales have different regulatory regimes. So in Scotland, there's the Town and Country Planning Environmental Impact Assessment Scotland Regulations 2017. In England and Wales, there's the Town and Country Planning Environmental Impact Assessment Regulations 2017. Very similar words, but different regulations. And in Raeshaw, the decision obviously that this webinar is following, the judge in that case, she said the Scottish regulations commence simultaneously with and are near identical terms to those applicable in England and Wales. It's worth noting that the wording isn't identical. And so there is, for example, express provision for applications for multi-stage consent in Scotland. You see that in Part 8 of the Scottish regs and also in Regulation 4. And so one of the things that we might get on to discuss shortly is the question of whether regulatory differences mean that there is a potential for a divergence of approach or not. But we'll leave that for now. Let's focus on the case law from UK jurisdictions. And in terms of what the line of cases that's probably helpful for everybody who's on this webinar to consider. The judgment in Raeshaw is very helpful from paragraph 22 of providing a pretty comprehensive survey of some of the decisions that I'm going to look at now. And so the first case that I'd like to talk about, and this is the first of two cases in Scotland which consider the scope and extent of EIA reports in the context of the legitimacy of separating a project into more than a single element. But you have the case of Skye Wind Farm Action Group and Highland Council, and that's from 2008. And so it's a wind farm application in that case. The challenge is brought against the grant of a planning permission to the wind farm and associated borrow pits. And it's argued in that case that the environmental statement, which was a precursor to what is now in Scotland an EIA report, was defective in excluding from consideration the effect of the borrow pits. And despite it being undisputed that the borrow pits formed an integral part of the wind farm development, the court was not satisfied in that case that it was illegal to separate the borrow pits from the assessment of the wind farm. There'd been an assessment in 2002 and then another assessment in 2006. Neither identified any significant environmental effects of the borrow pits, whether considered alone or cumulatively with the wind farm. And that case, it was said that you need to look at the particular circumstances of each case to consider whether cumulative assessment is needed to fulfill the purposes of the directive, and there's no practical reason for the EIA environmental impact assessment of the borough pits other than in the context of a wind farm application in the context of the facts that arose there. The second decision was a decision called Wildland and Highland Council, which is much later on in 2021. Another challenge to the grant of planning permission, in that case for the construction of a vertical launch spaceport with associated works. The site boundary went over 5 designated sites, and so the challenges in that case said that the relevant environmental impact assessment report hadn't considered the environmental impacts of proposed visitor facilities on the site. The court rejected that contention and said it wasn't an error of law because there was no salami slicing. There was a rational justification for not identifying the proposed location of the visitor facilities and not applying for planning permission to develop those facilities initially. The size of the launch exclusion zone in relation to the particular development wasn't clarified, and there was uncertainty as to the appropriate location of the things that were being talked about. And it was also noted in that case that the development of visitor facilities would require a further application for planning permission. So in that case, cumulative environmental impacts would be required to be assessed, but there would be a later consent which would be able to deal with that cumulative assessment. And so one of the things that's noted in the judgment in Raeshaw is that there was a knowledge in that case of a planning permission being required, whereas in Raeshaw it was said that the lack of knowledge as to whether such a consent was required for future work was relevant to the correct approach to the project splitting issue. What is a project? Well, many of you will be familiar with the case under the English and Welsh regulations of Wingfield and Canterbury City Council from 2020, Mrs. Justice Lang. That case was it concerned a planning permission for a mixed-use development of dwellings and a variety of civic spaces and associated infrastructure. And it was said that the local authority had failed to treat the development of 2 of the relevant parts of the development as a single project. Mrs. Justice Lang surveyed the domestic authorities, and she said the question as to what constitutes a project for the purposes of EIA regulations is a matter of judgment for the competent planning authority, subject to challenge on Wednesbury, rationality, or other public law error, and then provided a non-exhaustive list of relevant factors for consideration, such as, and I'm sure many of you are familiar, common ownership, whether 2 sites are owned or promoted by the same person, that might indicate that it's a single project. Whether there's a simultaneous determination, i.e. if there's 2 applications being considered at the same time, which cross-refer to reports to one another, that might indicate there's a single project. Functional independence, whether one part of a development could not function with another, that also might indicate that there's a single project. And standalone projects, where a development is justified on its own merits and would be pursued independently of another, that might indicate that it constitutes a single individual project and is not an integral part of a more substantial scheme. Just pausing there, it's worth noting that there is the reference to functional independence there. There's a case called Llandaff North Residents Association, which concerned two developments. There was a housing scheme and a wider pumping station. And in that case, it was held that the officer hadn't acted irrationally and the planning authority hadn't acted irrationally in finding that there was a functional relationship without being functional interdependence. That's obviously a fact-specific finding, and it might be said that there's an important difference between that case and the facts that arose in that case and the different context of a grid connection to a renewable project, which wouldn't exist without the renewable project. The next case was Ashchurch. This was from 2023, the Court of Appeal, and Lord Justice Lindblom gave the leading judgment. That's the Bridge to Nowhere case, which was well publicised at the time. A large housing development required the construction of a road bridge over a railway line and connecting roads. And the EIA report treated the bridge as a standalone project to be given consideration independently from environmental assessment of the highway and residential development it was going to facilitate. In allowing the appeal against the unsuccessful JR, the court emphasised the need to understand a project broadly and realistically, and said it was irrational for the road bridge that was part of a wider residential development to be subject the subject of an EIA that did not include the wider development. You cannot have one without the other, is how the court put it. The court cited the Court of Appeal's decision in Finch, obviously subsequently surpassed by the Supreme Court's decision. And Lady Justice Andrews said that the decision-making authority should consider the degree of connection between the development and its putative effects, and whether a particular consequence is truly in effect. And so in that case, the court held that the identity of a project for these purposes is not necessarily circumscribed by the ambit of a specific application for planning permission under consideration, and the objectives of the directive and regulations can't be circumvented, deliberately or otherwise, by dividing what is a single project into separate parts, i.e. the reference to salami slicing. And then in that case, the Court of Appeal supported Mrs. Justice Lang's approach in Wingfield to the question of what constitutes a project being a matter of judgment and the consideration of those principles we went through earlier. There was then the case of Together against Sizewell C and the Secretary of State for Energy Security and Net Zero, which was in 2023 Court of Appeal decision. That concerned appropriate assessment and a claim that the Secretary of State had erred in failing to carry out an appropriate assessment of the effects on European sites of the permanent supply of potable water to a proposed nuclear power station, either as part of the permanent supply, either as part of the same project or cumulatively as a separate but connected project. And that's obviously under the habitats regime instead. And the challenge was to a Sizewell C nuclear generating station order authorising the construction of a nuclear power station on the Suffolk coast. Lord Justice Lindblom, he upheld Miss Justice Holgate's first instance decision that the Secretary of State hadn't fallen into error, and said that a staged approach to assessment is in principle legitimate and will prevent what has been described as sclerosis in the planning system. In some cases, this will be the obvious and only realistic course to take. And then went on to say that determining the nature and scope of a particular project and whether two or more developments are properly to be regarded as a single project were not matters of law for the court, but of fact and evaluative judgment for the decision maker, subject to review by the court on a conventional Wednesbury basis. Now, that's obviously in the habitats context, and one of the things that we'll go on to look at with Raeshaw is whether the same principles stand in the particular context that we're considering here. And then finally, there was the decision in Finch from the Supreme Court in 2024, which obviously judgment was released in June, and on a lovely sunny day, England were playing in the European Championships and everything was good with the world. The local authority's decision was to grant, that was being challenged, was to grant planning permission in that case to extract petroleum. And it was said that that decision was unlawful because the environmental impact assessment had failed to assess the effect on climate of the combustion of oil to be produced, and because the reasons for disregarding that effect were flawed. The point to note of relevance for the present case is that it was found that it's essential to the validity of a decision under challenge that before it is made, there has been a systematic and comprehensive assessment of a project's likely significant effects on the environment, and public participation is integral to the process of assessment. And so that is a whistle-stop survey of the key case law. I think with one eye on the time, I'd like to then hand over to Joe to move us on to the case at hand.
Thanks, Jack. Yeah, James, in the context of all of that, along comes Raeshaw Farms. Probably best to tell us about the facts of it, and then put it as best, well, as you only can, in the context of what we've heard from Nina and Jack.
Well, thank you, Joe, and thank you, Jack and Nina. It's a decision by Lady Wise, and I'll leave it to you to judge whether her surname is a good example of nominative determinism or not. But she was sitting in a house. For those not familiar with the Scottish system, for in a house, read English Court of Appeal. Again, by way of introduction, for those not familiar to the Scottish system, for reporter in Scotland, read inspector in England, identical roles, but slightly different procedural provisions, both at reporter stage and at the court stage. So in this case in Scotland, there'd been no inquiry or hearing or really any other process. There'd been some exchange of some written submissions, but that was it. So the reporter had no debate on this issue before him. All he had was that Raeshaw had raised the issue, as the Inner House found clearly, and indeed the reporter dealt with it in one paragraph in his decision, again as set out in full in the Inner House's decision. So there was no debate on the issue before the reporter. He had to reach his own view, and reach it he did. It then went, this is the second point difference, it went straight to the Inner House. In Scotland, appeals under the Electricity Act, and this was an Electricity Act case, go straight to the Inner House. So there's no lower court decision in Scotland called the Outer House, equivalent of the High Court in England and Wales. So no previous decision by a first instance judge either. Just to be aware that if it had been a planning decision, the challenge would have been by way of judicial review, which would have gone to the Outer House first. That, however, is changing sorry, if it's a Section 36 case, my apologies, totally got that wrong. Planning case goes straight to the Inner House. Section 36 cases used to go by way of judicial review. From late February of this year, all appeals are now to the Inner House, and there's a permission stage too. There is a potential appeal to the Supreme Court. As far as I'm aware, no decision has been made on that one way or another. I simply don't know whether anybody is contemplating an appeal. Just again to note that if it does get to the Supreme Court, Lord Doherty, who's the newest Scottish judge in the Supreme Court, who dealt with the Caithness spaceport case that you were being told about a moment or two ago, maybe one to sit on the panel. So that's it by way of background. It was a wind farm application, but the wind farm application made absolutely clear there was no consideration of the grid connection in the EIA, notwithstanding the expected costs of the grid connection relied upon in the EIA in support of the economic impact assessment, which is, to my mind, a classic case of having your cake and eating it. The challenge was based on the absence of assessment of connection to the grid. Now, perhaps it's an important point to make, given some of the English cases. I was very clear that the challenge only related to connections to the grid, no suggestion that grid reinforcement or other grid provision that would have to be made in any event was necessarily part of the same project. The distance in this case, which I don't think is set out in the First Division's opinion, was 16 kilometres or thereabouts. So a fairly significant length, and the court was told that there was no certainty as to whether that was going to be undergrounding or whether there was going to be pylons or some form of overhead line. And as has already been said by Jack, there was no certainty in this case as to whether an overhead line or an underground connection would be the subject of any either planning application or indeed EIA assessment. So the challenge was made on the basis of existing English case law, which Jack has outlined, and Irish case law, which Nina has given us an introduction to, but they're all fully set out in the opinion of Lady Wise. The only point that one might want to make is that the English case law was already fairly settled, and she applied the English case law, in my view, obviously correctly, but in a fairly uncontentious way. The new provision or the new cases that were considered in depth for the first time, as far as I'm aware, in either England or Scotland, notwithstanding some brief references to one in Fry were the Southern Irish cases. So that was new, and the court's treatment of them was new. And perhaps less surprisingly, given it was a Scottish court, they paid significant attention to what the Irish judges had said. So the challenge was on two bases, perversity, and then on three separate grounds, but all related in respect to the EIA provisions. Now, perversity, which the Inner House dealt with second, didn't reach a wholly conclusive view on, but said they thought there was force in it, is a straight application of Ashchurch, that it's perverse to take into account the benefits of a project, but not the disbenefits. And in this case, the wind farm would not produce any of the benefits that weigh heavily in its favour if it cannot connect to the grid. But to connect to the grid, there are potential adverse environmental impacts. And leaving aside any nuances of EIA law, which is what we've been focusing on so far, a challenge on the basis of perversity succeeded in Ashchurch and succeeded in this case, insofar as one can tell from the way the judges dealt with it. All I would say is that in any case where you have a project where you take into account the benefits of something inevitably having to happen, so not a case where there might be a further expansion of the project and a heating pipe might be put in to provide heating to or power to an adjacent facility, but something that was inevitably needed to gain the benefits, you should take into account the disbenefits. And secondly, on the EIA, the reporter, the judge found, simply failed to address the question properly and failed to apply the criteria that, albeit they're not prescriptive, but any of the criteria that Mrs. Justice Lang had considered in Wingfield, and had failed to have regard to the real intention of the EIA directive, which is not concerned with people trying to pull a fast one. It's making sure that the right environmental information is there from the outset. And to my mind, it's really important for that reason, to distinguish between EIA cases and habitats regs cases, because in the latter, the important point is that a habitats reg decision should be taken and can be taken at any time up to the final decision. Whereas for EIA, the important point is that the information should be there from the outset to guide the decision process. The last thing I'll say, given the time, is that the importance of the Irish cases was to counter the arguments that were put forward and alluded to in the opinion from by Lady Wise, that the impact on the industry would be such that it would render the development of wind farms impossible or impractical, and those matters and the difficulties of getting a grid connection into and knowing where your grid connection is going to go at the time of your planning application for a wind farm. They were dismissed in the Irish cases. That line of argument clearly was found sympathy with the Scottish Inner House, and the last point to make on that is, although it's not referred to in the Inner House's opinion, one way potentially around that is to deal with, make use of the Rochdale envelope. If you don't know exactly where it's going to go, define a worst case basis, assess that, and that may be one way forward, but no doubt we'll come back to that. My apologies, Joe, if I've carried on too long, but
Absolutely
I'll
not.
pass you back to you.
No, there are no rules, James. When it comes to you, you can go on as long as you like. Imogen, we're gonna come to you now to kind of draw all that together. No pressure. you'll see from the Q&A that there have been a couple of questions that I think you'll probably cover anyway. One person asks the general question that we're all asking is what the heck should we do here? If and in the particular context of the question, where there has already been an application submitted and is going to appeal, but it's a if you like a salami sliced one, so it doesn't include the grid connection. What should they do? So I'm sure you were going to cover those anyway, but just to flag up that those are a couple of questions that are exercising our audience. Over to you.
Yep, thank you. And thanks for everyone's time. It's great to be with you all this afternoon. So I think this is the naughty question, is in the practical world where we're trying to bring forward our renewable projects, whether that's wind or solar, BESS or other types of developments, where alongside you all working on your generation applications and your projects is waiting on your grid connection offers. And in the world where we're all waiting for our gate 2 processes and for our grid connection offers, what do we do when we're trying to get consent for our main site applications and help to bring forward the project to market whilst we're still waiting on those grid connection offers? So I think the kind of questions that we need to look at are how do we give confidence, first of all, to decision makers that they can continue to determine applications robustly and securely and give confidence to those decisions in light of these questions. And I think that the kind of landing point firstly on there is that this case is an exploration, as we've been hearing, of standard EIA principles that have been quite long-standing. So it's setting down principles that are long-standing and trying to explain those. So the principle of salami slicing is well known and familiar to us all. This is trying to set that out in some more detail. So the first question is, how do we kind of give that confidence to decision makers? And there are some indications in the judgment itself. So as we've been hearing from James and others there from the cases, is there an approach to considering the application for the generation asset itself with the grid connection in some form? So when you're at your development stage and considering that question of what is my project, if I don't know the grid connection, can I answer that question in some way? Can I consider the grid connection options in some form of cumulative assessment, whether that is quite a low down scoping tiering project? So list it out in my scoping, list it out as a cumulative project, but perhaps quite low down in that tiering approach. So is cumulative assessment an option? Or we'd also been hearing, is there multi-stage consenting option here? So some form of assessment at the earliest stage, but then looking to future stages in the life of the project to bring forward more information to help supplement the EIA there. And then we're just to pick up on James's final point there, that really interesting question of, can we apply a Rochdale envelope approach to this and try and do some form of high-level site selection and screening information based on quite larger boundaries than we might otherwise desire, to try and bring forward what could be some form of environmental information to show how the grid connection has been considered by the project, and to give that information to the developer, give that information to the decision maker, and help them take a robust decision that is compliant with those EIA principles. I think from my perspective, one aspect that I would wish the judgment may have gone into more decision on, and I'm really keen to hear more in this as more cases come forward, is that the requirement under EIA is to assess likely significant effects. It's to assess those likely significant effects, but the key word that I'm trying to emphasise there is likely. And what it would be great to try and see, and we'll be keeping an eye on, is what the courts consider to be a likely effect, and what a decision maker considers is that bar, that standard of what is likely. Because I'm giving all those examples there of what we could do, I'm sure that many of you will be thinking that my project just doesn't know what its grid connection is going to be. So I could try and do a cumulative assessment, I could try and do some form of information, but my grid connection option is just not known to me. So then that question then of what do we do when we just don't know the grid connection at all, or it could be, such a wide boundary, is, well, is there then a stage when we can say in our decisions, in our EIAs, that there is just not enough information to consider a putative effect, a potential impact, as a likely significant effect, and to take a justification down those lines. And I think that's one aspect where I'd really be keen to track, to try and see what comes next. So all of those options that I'm talking about there, that those are the kind of practical options that we can consider on projects on a case-by-case basis to try and bring something forward. I think the other question, though, that remains to be seen is, even if a project does take that approach, does that address the perversity point that James is talking about there? So, and under the judgment, the last ground, the irrationality. So that's the question of, is it rational or was it perverse to take into account that the benefits of a generation asset without being able to assess the disbenefits? And I think at the moment it's an open question of whether, if you were to try and do some form of cumulative assessment, some form of multi-stage assessment, perhaps even a worst case scenario, that approach may not always fix that perversity or rationality question. And that's really where it gets down to case by case basis. What information and assessment is the project able to provide? So it's not a hopeless message. There are approaches that we can try to take in projects, and I hope that practically helps address some of the questions in the chat there. But I think the message that we have to take away from this judgment is, what can we try to do to show that the project question has been considered, it has been thought through by the developer, and what information can we try to do to give that decision maker the information they need to take a robust decision?
Fantastic. Thanks, Imogen. That's, I hope, good advice, although necessarily speculative at this time. I'm sure if you contact Imogen directly, then she'll give you more detailed advice if you need it on strategy. I can see everybody's coming back on camera, and we've got a few questions in the Q&A, and it may be that you've all been listening so intently that I'm taking careful notes that you haven't yet put your questions in. I'm just going to deal with these sort of in order. The way the Q&A works, I can see that Nina's answered one question in writing, so that's now been sort of moved. So that was the question from Alex Fornal. So that's in the answered section. So Alex, if you didn't see that, Nina's given you quite a detailed answer there, and we won't go back.
Sorry, Alex, for the thesis.
That's the Pindham way. It's good to have all the information. That was a sort of slightly more detailed question about a broader question, which is, we've talked a lot about cases where they found to be unacceptable salami slicing. Are there any that go the other way? I think Jack sort of mentioned a couple that do. Do we want to develop that at all? I mean, are there cases where salami slicing, if you like, has been found to be acceptable? That's not quite the right way of putting it, but that a project split was appropriate and didn't offend the regs.
I mean, there are lots of cases where, well, Jack takes himself off mute to contribute, where it was argued it was the same project, but the court held, well, it's a matter of Wensbury rationality. What is the project? But here, it clearly was a defensible decision. So if it is one and the same project, then as a matter of law, it has to be assessed within the EIA. So that's really the nub of it. And Imogen is absolutely right. I think given that you've got this public law reasonableness threshold for review by the courts, provided that's actually done, the fact-specific assessment has been carried out by the decision maker, then that covers you off, I think. I've got something else on this, but on this, like thinking ahead. So I'm going to pass over to Jack, and then we might come back and I can add in a little bit after that.
Yeah, I think I don't have loads to add. I mean, I think the point that I would make is that there's obviously a distinction between your assessment of what is the project and ensuring that there is an appropriate assessment of any cumulative impacts arising from development. And so I think that's an important distinction that needs to be made. But apart from that, I would echo what you've just said.
Nina, did you want to come back and deal with your next point? Yeah.
Yeah, because it's something that occurred to me in the course of answering Alex's question, and I realized I'd already typed way too much. So I'd stopped. And given that I've got the time and space now, I think I'm going to deal with it, which is that um, the lack of detail, because a lot of the time you've got the initial project, and that takes a huge amount of capital and resource just to get that defined. And then thereafter, um, the grid connection sort of comes once you get that connection. So, or once you get that consent. So it's not, the details aren't known. And it depends on the degree to which it's possible to assess. So I highlighted the Irish case law where the judge said, well, we're not really going to take much on board in terms of you complaining. It's really hard to do. But the English case law, it doesn't go the other way, but it does consider in more detail the nuance of that argument. So we have, for example, I think he was Mr. Justice Lindblom at the time in CAT in Brighton and Hove City Council, where he said that conjecture doesn't have a place in EIA. And then we have him again in Ex parte Hockley, where he said speculation doesn't have a place in EIA. And then Lord Leggett put them together in Finch at paragraph 77, where he said conjecture and speculation have no place in the EIA process. So if you're basically making details up just to be able to say this is what might come forward, that's not an appropriate way forward. So if you're engaging in conjecture or speculation, then stop right there. You're wasting your valuable resources and time. And that's not part of the project because it's the case law makes very clear that's not something EIA is meant to capture.
Do you want to just in that context just draw on what Imogen said about likely and the word likely, because it seems to me that those are connected questions. I mean, we don't know yet what the court's going to think about those kinds of arguments, but it sounds like Imogen's going to be making them soon.
Yeah.
What does anybody think about that?
And whether I'm defending it, I hope that would be the case. Well, we've got Bateman, where the court said likely more than a bare possibility suffices, but we don't have anything beyond that. And when in the course of preparing for this, there's so much interesting academic research that could come out of it. You've got Wensbury thresholds for review of certain aspects of EIA decision making, and then you have the courts willing to say, no, this is a matter of law for us. So if it's within a category of Schedule 2, that's a matter of law for the courts. If it's an indirect effect, Finch, that's a matter of law for the courts. Where the line is, if it's the interpretation of a word, obviously that's a matter of law. But you also get these interesting questions on the boundaries, like whether it's likely or not, where the courts have ventured into attempts to give us some judicial guidance and define that term. But we've got nothing beyond that. And really, I completely agree with Imogen. It's going to come down to that at some point. This will be litigated and we'll get a little bit more clarity on where that boundary is, hopefully.
It also strikes me, and I promise we will come to some more questions. It also strikes me that there's a nexus here, isn't there, between the rationality argument in Raeshaw, where on the one hand, where it's irrational to take into account the benefits but not the disbenefits, and that would point towards it being part of the same project, it seems to me. I mean, they're obviously connected points, but there's also entirely separate case there, isn't there, about benefits not having to be absolutely definitely secured before they can be taken into account, not in this particular context. So a decision maker can, in a planning case, take into account benefits which are not secured but might be under a best endeavours clause in a section 106. I think there's a particular case on that. So again, this stuff all feels quite ripe for judicial opinion, basically, from both ends of the telescope. Both on that kind of rationality idea, but also in terms of what's likely or what's in scope, even in the project.
Yeah.
That's a relief that you agree.
Well, I mean, you ask a barrister if it's right for litigation, we're always going to say yes, aren't we? But undoubtedly, look at this. We've had salami slicing, excuse me, it's been a long week. We've had salami slicing cases for 25 years and they just keep coming thick and fast. It's not something that's, going to be definitively settled in one case, I don't think. We're going to get there bit by bit.
There's a couple of sort of technical points which I think we can answer quite quickly. And Jack, I'm sort of looking at you for these. One of them, Mark Cope asks, how does the judgment affect projects where the potentially two parts of the same project are consentable under separate regimes? And I think the answer is it doesn't. I think they fall under the same question of are they a project? But does anyone disagree with that? I mean, the particular example given is Town and Country Planning EIA and then Electricity Act regs in Wales. I think the consenting regime is largely irrelevant to the question of whether it's a project. I mean, it might be part of the question, but it doesn't. James, you've got an answer.
Yeah, just to say that the Inner House made it quite clear it doesn't have to be the same application. All that is required, and just picking up the point that Jack made, is that if it's one project, the EIA that you're considering needs to cover the whole project. And it's a separate point if there are separate projects, whether they've dealt with the cumulative issue correctly.
Yeah, and Ashurch is similarly
the application doesn't matter.
And the other sort of technical one, which I think we can answer quite quickly, and I won't answer this one, is about, it's really a question of kind of European law and direct effect. Post Brexit, are the regs still tied to the directive? I mean, Jack's sort of nodding. I think in principle.
Well, so we're not bound by the directive in the same way as member states are, but essentially the regulations are retained EU law, and so until and unless Parliament decided to depart from the approach in the EIA directive, then we still align with the EIA directive. And for interpretation purposes, you see in Finch that they talk about it's appropriate to look at the EIA directive directly for the purposes of interpreting the provisions of the EIA regulations.
And similarly, of course, the pronouncements of European judges where there is direct effect on what the meaning of the sort of base regulations are is obviously going to be a material consideration in the kind of standalone English system.
I can quickly answer two questions, Joe. Sorry, I'm taking over control. Unruly panelist. You're downstairs, so you can yell at me later. In answer to Marcus Trinick KC's question, yes, I agree. Paragraph 77 of Finch, and also the EIA regs themselves, in both jurisdictions, I believe, and certainly it's in the EIA directive itself. The assessment has to be reasonable. If you're making it up, that's not reasonable. So if it's unknown, entirely unknown, it has to be, the EIA can only be based on the available knowledge at the time. That's also established case law. So I agree with you there. And Vanessa Thorpe, yes. And this is exactly what happened post-Finch. Everyone said, well, what are the boundaries of the waves of concern that are coming out about how to carry out EIA when Scope 3 is scoped in? And we are working that out, and no doubt we'll be working that out here. But there's no reason in my mind that this is exclusively wind farms and grid connections. It just happens to be there's a lot of wind farm development and grid connections being litigated.
Yeah, I agree with that. James, should we come to this issue of sort of multi-stage consent and how that might work? I'm looking at you, but I think everyone's probably got something to say about that.
Absolutely. Just one thing before we get to that. Obviously, the wind farm industry in Southern Ireland has had to cope with this approach for some time. I don't know how they managed to make it work, but I'm certainly not aware that wind farms of development has jutted to a halt in Southern Ireland. May have done, but there are ways of making it work, and some of the subsequent cases show that. The multi-stage consent provision is there are provisions in the Scottish regs which are not in the English regs, which Lady Wise referred to in her opinion, which and Jack has alluded to in Regulation 4 of the Scottish regs, that if Regulation 4 sub-regulation 6 applies, then there's certainly an arguably that the EIA doesn't need to cover every aspect, and subparagraph 6 would apply if the decision maker thinks that the likely significant effects of the development are not fully identifiable at the time of their determination, and that they're minded to grant planning permission for EIA development subject to a multi-stage condition. I haven't seen that argued out in any cases in Scotland. I haven't seen how that might work in practice, but it would appear to cater for the position where you don't know, it might cater for the position where you don't know where your grid connection is going to be at yet. So you might have a multi-stage condition, which perhaps I'm more familiar with than in HRA terms, but a multi-stage condition which prevents development going forward until an EIA covering the full part of the project is dealt with. That is very much a preliminary view at this stage. I haven't seen it tested. And it would appear to be only have a statutory basis in Scotland, not in England, as far as I'm aware. But that's my understanding of the multi-stage consent and multi-stage conditions. And Lady Wise clearly thought it was important because she expressly referred to them in her, I think it's paragraph 7 of her opinion.
Anybody want to add to that? I mean, there's obviously the general question, which is at large, which is what should developers do? And one of the questions is, should they be sort of front-loading and thinking about grid connection? Should they be thinking about that earlier? This is perhaps another example. Should they be trying to find a way of deferring that, essentially?
Yeah, I think just picking up on that. So I'm aware that was a feature of some of the very earliest discussions in the offshore wind market in Scotland, but it never came before the courts. It was just a part of the early discussions and in the early consent. So I don't think that has been tested, as you say, James. I think the question that a developer would be asking is, well, that's quite a different concept from bringing a project to market now. So how would that fit with a funding scenario, an investment scenario, and even things like how would that fit with your compatibility for any offtake agreement, grid agreements that you have in place. So I think that maybe a consenting question where there are quite a lot of ramifications for the route to market for a project would need to be thought through.
Fantastic.
I'm conscious of the time, so I don't know if I should jump in here. I'll very quickly. It's a really, really interesting question. I think I'd advise caution, extreme caution in all of this because it is such a litigious area. But with conditions, there's the Hardy case, I think, to do with bats, and let's take care of this later, just in case. And that was quashed because the judge said you have to, if there's nobody knew if there were bats there or not. That's important. But even then, the judge took the precautionary, very precautionary approach of saying you need to know if there's a risk of a risk. And so all information for the purposes of the EIA directive needs to be at the time of the decision. So putting in a condition that we'll get that information later, where that information could exist, was considered unlawful. I have to say, I've not seen Hardy type arguments succeed since, but that might just be because of the extreme caution of people imposing conditions. I'm not sure. I'm going to stop there because it's 4 minutes past, and I suspect people have lives to get onto.
They do. There are loads of questions which we aren't going to get to. Yeah. That's just the nature of these things, but also an indication of the relevance and level of interest in this stuff. I mean, I'm sort of duty bound to say that those of you that have burning questions that need answering, you know our telephone number, and please do get in touch, and we're all happy, I know, to discuss those things. But given that it is 5:05 and it is quite late in the day, can I just thank all four of you, first of all, for coming and sharing your knowledge of it and for doing it so quickly after the decision. I know that's really helpful for people to get an early view, but also perhaps even more so for so many of you coming along to listen and ask such pertinent and excellent questions, which really helps with these webinars. So look, thank you very much, everybody, attendees and panelists alike.